Sir, you can't be in here. This courtroom is for scheduled hearings only. Officer Kevin Miller's voice carried across the nearly empty housing court as his hand moved instinctively toward his radio. The man sitting in the front row looked up from his legal pad, his expression calm and measured. He wore a simple navy blue suit, no tie, and carried a worn leather briefcase that had seen better days. Nothing about him suggested authority or power. To everyone watching, he was just another tenant trying to navigate the housing court system. Judge Terrence Washington had arrived early, as he always did, to review case files before the morning session. At 45, he believed in preparation and punctuality. His practice of sitting in the gallery to observe the room's dynamics before taking the bench had served him well over his 8 years on the housing court. It helped him understand the real atmosphere tenants experienced when entering his courtroom. Officer Miller stepped closer, his boots echoing on the marble floor. The Hamilton County Housing Court building was old, built in 1952 with high ceilings and windows that let in harsh morning light. Sir, I need to see your hearing notice. You can't just sit anywhere you want. 3 people in the back rows had their phones out already. The live stream culture had reached even housing court proceedings, where tenants often documented interactions with authority figures. User at Renters' Rights was already tweeting about police harassment in housing court before 9 a.m. Terrence held up a manila folder filled with documents. I have court business today, officer. I'm reviewing files before the session begins. Miller's eyes narrowed as he examined the folder from a distance, not bothering to actually look at its contents. Sir, tenants wait in the designated area until their cases are called. This section is reserved for court personnel and attorneys. Around them, the morning crowd was slowly gathering. Mrs. Betty Foster, 67, clutched her eviction notice while trying to calm her crying granddaughter. College student David Kent checked his phone nervously, worried about missing his part-time job for this hearing. Single mother Kiara Johnson bounced her toddler on her hip while juggling her purse, diaper bag, and legal documents. Officer, Terrence said quietly, I think there might be some confusion here. Perhaps you could check with court administration about my presence. Miller shook his head dismissively. Sir, I've been working courthouse security for 6 years. I know who belongs where and when. You need to move to the back with the other tenants. The 3 phone cameras were now recording openly. One teenager was streaming live on TikTok with the caption, Housing Court Drama Already Starting. The morning hadn't officially begun, but social media was already buzzing. Terrence opened his briefcase methodically. Inside were case files, legal precedents, and administrative documents that would guide the day's proceedings. He pulled out his court identification card and placed it on the wooden rail in front of him. Officer Miller barely glanced at it. Anyone can make fake IDs nowadays. Sir, I'm asking you politely to move to the designated waiting area. Mrs. Foster whispered to the woman beside her, Why is that officer hassling that nice young man? He wasn't bothering anybody. Her voice carried in the echoing chamber. Terrence looked at his watch. The court session was scheduled to begin in 23 minutes. As presiding judge, he needed to review 12 eviction cases, 3 rental disputes, and 1 appeal. But first, he needed to address this situation without escalating it. Officer Miller, Terrence said, maintaining his measured tone, I understand you're doing your job. However, I have legitimate business in this courtroom. Perhaps we could resolve this by checking with Sheriff Foster or Captain Stevens. Miller's hand moved to his radio. Control, I need a supervisor at housing court. I have a non-compliant individual refusing to follow courtroom protocols. The static crackled back. Copy that, Unit 47, supervisor en route. Kiara Johnson had stopped bouncing her toddler. She was watching the interaction with growing concern. recognizing the familiar pattern of authority figures making assumptions about black men in professional settings. Her own brother had experienced similar treatment at the county courthouse when he'd tried to file business incorporation papers. Terrence reached into his briefcase again and withdrew a leather portfolio containing his judicial credentials, oath of office, an appointment letter from the governor. The documents bore official seals and signatures that would be impossible to forge. "Officer, these are my judicial credentials. I'm Judge Washington, and this is my courtroom." Miller looked at the documents like they were written in a foreign language. "Sir, I don't know where you got these, but impersonating a judge is a felony. I'm going to need you to step outside until my supervisor arrives." The live stream on TikTok now had 400 viewers and climbing. Comments flooded in. "This cop is about to get embarrassed." "Plot twist incoming." "Someone's getting fired today." David Kent leaned forward in his seat. He'd been to housing court twice before and had seen Judge Washington preside over cases with fairness and patience. The judge always arrived early and often sat in different parts of the courtroom to observe the proceedings from various perspectives. Terrence closed the portfolio and placed it back in his briefcase. "Officer Miller, I'm going to give you an opportunity to reconsider your position. I suggest you contact Court Administrator Linda Parker or Sheriff Amanda Foster to verify my identity." Miller's radio crackled again. "Unit 47, Captain Stevens is 5 minutes out. Can you maintain the situation until arrival?" "Affirmative," Miller responded, his eyes never leaving Terrence. "Sir, you're going to wait right here until my captain arrives. And if these documents are fake, you're looking at serious charges." Mrs. Foster had finished organizing her documents and was now openly staring at the confrontation. She'd appeared before Judge Washington 6 months ago when her landlord had tried to evict her for late rent. The judge had listened patiently to her explanation about her fixed income and medical bills, then worked out a payment plan that kept her in her apartment. The elderly woman stood up and walked slowly toward the front of the courtroom. "Officer," she said in a voice that carried the authority of 7 decades, "that's Judge Washington. He's the one who helped me keep my apartment last year." Miller turned toward her with visible irritation. "Ma'am, please return to your seat. You're interfering with police business." But Mrs. Foster had been alive too long to be intimidated by a young officer's attitude. "Son, I've been coming to this courthouse longer than you've been alive. I know Judge Washington when I see him." The TikTok live stream had reached 800 viewers. The comments section was exploding with outrage and disbelief. Several viewers were already sharing the stream on Twitter and Instagram, spreading the incident across social media platforms. Terrence stood up slowly, his full height of 6 feet 2 inches commanding attention. He moved with the deliberate grace of someone accustomed to authority, though his demeanor remained calm and professional. "Officer Miller," he said, his voice carrying a tone that somehow seemed both patient and final. "In approximately 3 minutes, Captain Stevens is going to arrive. When he does, you'll discover that you've just attempted to remove a sitting judge from his own courtroom. I'm offering you a chance to reconsider your actions before that moment arrives." Miller's confidence wavered for the first time. Something in Terrence's voice, in his bearing, in the way he commanded the space around him, suggested this wasn't just another tenant trying to talk his way out of trouble. But Miller had committed to his course of action, and backing down now would mean admitting error in front of a growing crowd of witnesses and recording devices. "Sir, I don't care who you claim to be. Courtroom security is my responsibility, and you're disrupting the proper order of this court." Kiara Johnson's toddler had grown quiet, sensing the tension in the room. She pulled out her phone and began recording. adding to the multiple video feeds already capturing the incident. David Kent was Googling furiously on his phone, pulling up the Hamilton County Housing Court website. Judge Washington's photo appeared clearly on the judicial roster, along with his biography and credentials. Kent held up his phone to show the woman sitting next to him, who gasped audibly. Terrence checked his watch again. 18 minutes until court was scheduled to begin. 12 eviction cases on the docket meant 12 families, whose housing stability hung in the balance. Mrs. Foster needed her case reviewed. The college student was clearly nervous about his first court appearance. The young mother with the toddler had paperwork suggesting a wrongful eviction claim. But first, this situation needed resolution. The heavy courtroom doors opened with a metallic groan. Captain Robert Stevens entered, his 30-year veteran presence immediately apparent. At 54, Stevens had seen every type of courtroom drama imaginable. His gray hair was perfectly groomed, his uniform immaculate, and his expression suggested he'd rather be anywhere else at 8:42 on a Tuesday morning. "Miller, what's the situation?" Stevens asked, his voice carrying the authority of 3 decades in law enforcement. Miller straightened to attention. "Captain, I have a subject claiming to be Judge Washington. He's refusing to comply with courtroom seating protocols and has presented what appear to be fraudulent judicial credentials." Stevens looked at the man in question, taking in the professional attire, the calm demeanor, the expensive briefcase, and the way he carried himself. Something didn't align with Miller's assessment. "Sir," Stevens addressed Terrence, "could you please state your name and business in this courtroom?" "Judge Terrence Washington, Hamilton County Housing Court. This is my courtroom, Captain Stevens. I believe Officer Miller may have made an understandable error in identification." Stevens had worked courthouse security long enough to recognize real authority when he encountered it. The man's voice, his posture, and his comfortable familiarity with the courtroom environment all suggested legitimacy. "Judge Washington, could you provide identification for verification?" Stevens requested, his tone respectful but thorough. Terrence handed over his judicial credentials, his state bar card, and his courthouse identification. Stevens examined each document carefully, comparing photos, checking dates, verifying official seals. The live stream viewers had grown to over 1,200, with comments flowing faster than anyone could read them. "This is about to get good." "Officer bout to get humbled." "Somebody call a lawyer." Miller watched nervously as his captain's expression changed from professional skepticism to obvious recognition. Stevens looked from the documents to Terrence, then back to the documents. "Officer Miller," Stevens said quietly, "step outside with me for a moment." But Terrence interrupted. "Captain, perhaps we could resolve this here. I believe transparency serves everyone's interests better than private conferences." The gathered crowd, now numbering about 20 people, pressed closer. Mrs. Foster nodded approvingly. David Kent was still live streaming on his phone, his viewer count steadily climbing. Stevens looked around the room at the phones, at the watching faces, at the delicate situation that was rapidly becoming a public spectacle. "Your Honor," Stevens said formally, acknowledging Terrence's position, "I apologize for this misunderstanding. Officer Miller was following standard security protocols, though perhaps with excessive enthusiasm." Terrence nodded graciously. "Captain Stevens, I appreciate your professionalism. However, I think this incident raises important questions about assumptions and protocol enforcement that we should address comprehensively." Miller's face had gone pale as the reality of his mistake became clear. He'd just attempted to eject a sitting judge from his own courtroom, questioned his credentials, and threatened him with arrest for impersonating a judicial officer. "Your Honor," Miller began, his voice shaking slightly. "I didn't realize. I apologize for the error." "Officer Miller," Terrence interrupted gently, "what assumptions led you to conclude I didn't belong in this courtroom?" The question hung in the air like a challenge. Everyone present understood the implication, but Terrence wanted it addressed directly rather than swept aside. Miller looked around desperately, seeking an escape from a truth everyone already recognized. I assumed you were here for a hearing, Your Honor. The front section is usually reserved for court personnel." "And what specifically made you assume I was a tenant rather than a judge?" Terrence pressed. "The live stream comments were brutal." "Say it out loud, officer." "We all know why he assumed. This is 2025, not 1955. Miller's silence was answer enough, but Terrence wasn't interested in public humiliation. He was interested in systematic understanding and change. "Captain Stevens," Terrence continued, "how often do your officers receive training on implicit bias and assumption-based decision-making?" Stevens looked uncomfortable. "We have annual diversity training, Your Honor, but perhaps it could be more comprehensive." Mrs. Foster stepped forward again. "Judge Washington, this young officer needs to understand that respect isn't about what someone looks like or how they dress. You've always treated everyone in this courtroom with dignity." The crowd murmured agreement. Several people nodded, recognizing the judge, who had handled their cases fairly and patiently. Terrence looked at his watch one final time. Court would begin in 8 minutes. He made a decision that would transform this incident from a simple misunderstanding into a catalyst for institutional change. "Officer Miller, Captain Stevens, I'd like to propose that we use this incident as a learning opportunity rather than a disciplinary matter, but I have conditions." Both men waited, understanding that their immediate futures hung in the balance. "First, Officer Miller will undergo comprehensive bias recognition training within 30 days. Second, all courthouse security personnel will participate in enhanced diversity and inclusion training. Third, we'll implement a protocol requiring verification checks before assuming anyone's status or role in this courthouse." Stevens nodded immediately. "Yes, Your Honor, whatever you recommend." "And fourth," Terrence continued, "we'll document this entire incident as a case study for training purposes. The recorded video from today will be used to train other officers about the dangers of assumption-based policing." The live stream had reached 2,000 viewers, with shares spreading across multiple social media platforms. But more importantly, the people present in the courtroom had witnessed something unprecedented, a person in power using their authority not for revenge, but for education and systematic improvement. "Officer Miller," Terrence said directly, "do you understand why your assumptions were problematic?" Miller nodded, his embarrassment visible, but his willingness to learn apparent. "Yes, Your Honor, I made judgments based on appearance rather than evidence. It won't happen again." "Good," Terrence replied. "Now, let's begin today's court session. We have 12 families whose housing situations require our attention." As the crowd settled into their seats and Officer Miller took his position at the back of the courtroom, the live stream viewers realized they'd witnessed something remarkable. Not just an incident of mistaken identity, but a masterclass in transforming conflict into opportunity for positive change. Court was about to begin, but the real session on justice, dignity, and systematic reform had already concluded. The gavel fell precisely at 9 a.m., its sharp crack echoing through the Hamilton County Housing Court. Judge Terrence Washington had taken his position at the bench, the morning's incident now a stark contrast to his current commanding presence. The same man who Officer Miller had attempted to remove 30 minutes earlier now presided over the courtroom with quiet authority. "Good morning," Judge Washington began, his voice carrying clearly to every corner of the chamber. Before we proceed with today's docket, I want to address what many of you witnessed earlier this morning. Mrs. Foster straightened in her seat. David Kent paused his note-taking. Kiara Johnson shifted her toddler to her other hip, sensing something significant was about to unfold. The live stream viewers, now numbering over 3,000, leaned closer to their screens. What occurred here today was not simply a case of mistaken identity. It was a manifestation of systemic bias that affects how people are perceived and treated within our justice system. Officer Miller made assumptions based on appearance, assumptions that could have denied access to justice if applied to any of you. Captain Stevens stood at attention near the back doors, his expression grave. Officer Miller remained at his post, but his earlier confidence had been replaced by thoughtful attention to every word the judge spoke. This courtroom serves some of our community's most vulnerable residents, people facing eviction, fighting wrongful charges, seeking protection from predatory landlords. If officers make assumptions about who belongs here based on appearance, they could inadvertently deny justice to the very people this court exists to protect. Terrence looked directly at the phone, still recording throughout the gallery. This incident will serve as a catalyst for change, not just in this courthouse, but hopefully in courthouses across the country where similar assumptions might be made daily. The first case on the docket was Mrs. Foster versus Hillcrest Property Management. The 67-year-old woman approached the defendant's table with small, careful steps. Her landlord's attorney, a young white man in an expensive suit, was already reviewing his files with confident efficiency. "Your Honor," the attorney began, "Hillcrest Property Management seeks possession of the rental unit due to non-payment of rent. The tenant owes $3,400 in back rent plus late fees." Mrs. Foster had no attorney. She represented herself with a manila folder containing receipts, medical bills, and handwritten notes documenting her attempts to communicate with the property management company. "Mrs. Foster," Judge Washington said gently, "please tell the court your side of this matter." "Your Honor, I've lived in that apartment for 8 years, never missed rent until my granddaughter got sick and I had to take care of her, lost work, had medical bills. I tried to call the landlord to work out a payment plan, but they wouldn't talk to me." The property management attorney shuffled his papers impatiently. "Your Honor, financial hardship doesn't excuse breach of contract. The lease clearly states that rent must be paid by the first of each month." Judge Washington examined Mrs. Foster's documentation carefully. "Mrs. Foster, I see you made partial payments in October and November. Have you been able to return to work?" "Yes, Your Honor. My granddaughter is better now. I can pay $850 a month starting next month, plus $200 toward the back rent." The live stream chat was following the case closely. Viewers were witnessing not just the aftermath of the morning's incident, but the daily reality of housing court, where families' stability hung in the balance. "Your Honor," the attorney interjected, "my client has already incurred significant costs pursuing this eviction. They're not obligated to accept partial payments or payment plans." Judge Washington looked at the attorney with the same measured attention he'd given Officer Miller earlier. "Counselor, does your client prefer to have a paying tenant who catches up on rent or an empty apartment that generates no income while they search for new tenants?" The attorney paused, clearly not having considered the business logic of his client's position. "I'll give your client 48 hours to consider Mrs. Foster's payment proposal. If they reject it, we'll proceed with the eviction hearing. However, I want to note for the record that Mrs. Foster has demonstrated good faith efforts to communicate and resolve this matter." Mrs. Foster's relief was visible. She nodded gratefully to the judge, understanding that she'd been given a genuine opportunity to save her home. The second case involved David Kent, the nervous college student. He approached the defendant's table carrying a backpack that clearly contained textbooks alongside his legal documents. "Mr. Kent, you're representing yourself in this matter?" Judge Washington asked. "Yes, Your Honor. I can't afford an attorney." The plaintiff was Kent's former landlord, claiming $2,800 in damages to a rental unit Kent had vacated 3 months earlier. "Your Honor," the landlord's attorney began, "the defendant caused substantial damage to the rental property, requiring extensive repairs and cleaning." Judge Washington reviewed the photographic evidence submitted by both parties. "Mr. Kent, do you dispute causing this damage?" "Your Honor, those photos were taken after I moved out, but they show normal wear and tear, not damage. I lived there for 2 years, always paid rent on time, and I cleaned the apartment thoroughly when I left." Kent opened his backpack and pulled out his own photographs, showing the apartment's condition on his move-in date and his move-out date. The judge compared both sets of photographs carefully. The landlord's photos showed scuffed walls, worn carpet, and minor stains. Kent's photos showed similar conditions upon move-in, with clear improvement after his residency. "Counselor, these photographs suggest your client is attempting to charge the defendant for pre-existing conditions and normal wear and tear, which violates state tenant protection laws." The attorney shifted uncomfortably. "Your Honor, the lease agreement holds the tenant responsible for any damage beyond normal use." "The lease agreement cannot supersede state law," Judge Washington replied firmly. "Mr. Kent's security deposit should be returned within 30 days. Case dismissed." David Kent's gratitude was obvious as he packed up his documents. He'd been prepared for the worst, but had received fair treatment based on evidence rather than assumptions. The third case brought Kiara Johnson to the defendant's table, still carrying her toddler. Her landlord was attempting to evict her for alleged lease violations that Kiara claimed were retaliatory. "Ms. Johnson, please explain your understanding of this eviction notice." "Your Honor, I complained to the city about mold in my apartment that was making my baby sick. 2 weeks later, my landlord served me with an eviction notice claiming I violated the lease by having unauthorized guests." The landlord's attorney presented their case with documentation of alleged lease violations. However, Judge Washington noticed the timing correlation between Kiara's health department complaint and the eviction notice. "Counselor, the timing of this eviction notice, immediately following a health department complaint, suggests possible retaliation, which is prohibited under fair housing laws." "Your Honor," the attorney protested, "the lease violations are legitimate regardless of timing." Judge Washington examined the evidence more closely. The alleged violations were minor and technical, the type typically addressed with warnings rather than evictions. "Ms. Johnson, have you documented the mold problem in your apartment?" "Yes, Your Honor." Kiara pulled out photographs of black mold around her bathroom and kitchen, plus a health department report confirming the presence of hazardous conditions. "This appears to be a retaliatory eviction, which violates federal and state fair housing laws. Case dismissed. Furthermore, I'm ordering the landlord to remediate the mold problem within 30 days or face contempt of court charges." The live stream viewers were witnessing something remarkable. The same judge who had been treated with disrespect and suspicion earlier was now ensuring that vulnerable tenants received equal protection under the law. But the morning's most significant moment came during the fourth case. The plaintiff was Riverside Property Group, represented by attorney Amanda Foster, a sharp-dressed woman in her 40s. The defendant was Damon Clark, a black man in his 30s who worked construction. "Your Honor," Attorney Foster began, "Mr. Clark has violated his lease agreement by conducting business from his residential property." without proper permits. Clark represented himself, carrying a folder of handwritten notes. Your Honor, I do small repair jobs for neighbors. I don't run a business from my apartment. I just store my tools there. Judge Washington reviewed the lease agreement and the alleged violations. Mr. Clark, do you advertise services from your residence or conduct commercial meetings there? No, Your Honor. I work construction during the day. Sometimes neighbors ask me to fix things after work. I help them out for a little extra money. Attorney Foster interjected, Your Honor, Mr. Clark's activities violate the residential-only clause of his lease agreement. Our client has the right to enforce lease terms consistently. Judge Washington looked at the attorney with interest. Ms. Foster, does your client enforce this lease clause consistently against all tenants? Of course, Your Honor. All tenants are held to the same standards. The judge opened his laptop and accessed the county business license database. Mr. Clark, have you ever applied for business licenses or permits for repair work? No, Your Honor. It's just helping neighbors, not a real business. Judge Washington continued typing, accessing public records. Interesting. Ms. Foster, I noticed that another tenant in the same building, a Mr. Jeffrey Adams, operates a computer consulting business from his apartment, Unit 4B. He has business licenses, advertises online, and conducts client meetings in his residence. Attorney Foster's confident expression faltered. Your Honor, I'm not familiar with that tenant's specific situation. But your client hasn't initiated eviction proceedings against Mr. Adams for lease violations, despite his clearly commercial activities. Can you explain this discrepancy? The courtroom had grown completely silent. Even Kiara Johnson's toddler seemed to sense the importance of the moment. Your Honor, Foster replied carefully, I would need to review Mr. Adams's lease agreement and circumstances. I've already reviewed both lease agreements, Judge Washington continued. They contain identical language. Both tenants are conducting business-related activities from their residences. One tenant, who is white, faces no consequences. The other tenant, who is black, faces eviction. The livestream chat exploded with comments about discriminatory enforcement. Viewers were witnessing not just justice in action, but a systematic examination of unequal treatment. Ms. Foster, this appears to be selective enforcement based on race, which violates fair housing laws. I'm dismissing this case and referring this matter to the Ohio Civil Rights Commission for investigation. Attorney Foster gathered her papers quickly. Your Honor, I don't believe there was discriminatory intent. Intent is not required for fair housing violations, Ms. Foster. Impact is sufficient. Mr. Clark, you may continue your current living arrangements without interference. Damon Clark's relief was visible as he packed up his handwritten notes. He'd expected to lose his apartment, but instead had received protection from discriminatory treatment. The morning continued with similar attention to detail and fairness. Case after case demonstrated Judge Washington's commitment to equal treatment under the law, regardless of appearance, economic status, or representation. During a brief recess, Captain Stevens approached the bench. Your Honor, I wanted to personally apologize for this morning's incident and assure you that training improvements will be implemented immediately. Captain, I appreciate your professionalism. However, I'm more interested in systematic change than individual apologies. How do we ensure this doesn't happen to other people who don't have the advantage of my position? Stevens considered the question seriously. We could implement identification verification protocols before questioning anyone's presence in courtrooms, and mandatory bias training for all personnel, not just annual refresher courses. Excellent suggestions. I'll also be recommending courthouse policy changes to the judicial administration. Anyone should be able to observe court proceedings without being challenged based on appearance assumptions. When the court resumed, the live stream audience had grown to over 5,000 viewers. News outlets were beginning to pick up the story, and social media was buzzing with discussions about bias in the justice system. The final case of the morning involved an elderly white man being evicted for hoarding violations. Judge Washington treated him with the same patience and fairness he'd shown all morning, ensuring he had resources for mental health support and a reasonable timeline for addressing the hoarding issues. As the session concluded, Judge Washington addressed the courtroom one final time. Today began with an incident that could have been dismissed as simple misunderstanding. Instead, we've used it as an opportunity to examine how assumptions and bias affect access to justice. Mrs. Foster nodded approvingly from the gallery. David Kent was taking notes for a paper he'd decided to write about bias in the legal system. Kiara Johnson was ensuring her toddler hadn't disturbed anyone during the proceedings. Every person who enters this courtroom deserves to be treated with dignity and respect, regardless of their appearance, economic status, or legal representation. Today's cases demonstrate that equal treatment under law requires constant vigilance against unconscious bias. The live stream viewers were witnessing something unprecedented, a public official using his authority not to retaliate or embarrass, but to educate and create positive change. Officer Miller remained at his post, but his posture suggested thoughtful reflection rather than defensive positioning. The morning's events had clearly affected him profoundly. I want to thank Officer Miller and Captain Stevens for their willingness to learn and adapt. Growth requires admitting error, and both men have demonstrated that courage today. As the courtroom began to empty, several people approached the bench to thank Judge Washington personally. Mrs. Foster shook his hand warmly. David Kent asked for advice about law school. Kiara Johnson expressed gratitude for fair treatment, but the most significant moment came when Officer Miller approached the bench after everyone else had left. Your Honor, I want to personally apologize and thank you for handling this morning with such professionalism. I learned something important today about my own assumptions and biases. Officer Miller, change happens when people are willing to acknowledge their mistakes and commit to improvement. Your willingness to learn demonstrates character. Miller nodded seriously. I'll complete whatever training you recommend, and I'll make sure other officers understand what happened here today. As the courtroom emptied, Judge Washington remained at the bench, reviewing the morning's events. The live stream had ended, but the social media discussion was just beginning. The incident would likely generate news coverage, academic analysis, and policy discussions. More importantly, 12 families had received fair hearings. Several had avoided wrongful evictions, and one had been protected from discrimination. The justice system had worked as intended when bias was recognized and addressed systematically. The morning had begun with assumptions and misunderstanding. It had ended with education, accountability, and positive change. That transformation, Judge Washington reflected, was exactly why he'd chosen to serve in housing court, where he could make a direct difference in people's lives. Court would reconvene after lunch, but the lessons from this morning would continue long after the final gavel fell. By noon, the live stream footage from Hamilton County Housing Court had been viewed over 50,000 times across multiple social media platforms. Local news stations were already assigning reporters to cover the story, and the courthouse communications office was fielding calls from journalists across the state. Jasmine Brooks, chief investigative reporter for Channel 7 News, had been monitoring social media trends when the housing court incident crossed her feed. At 34, Brooks had built her reputation exposing systemic inequalities in local government institutions. She recognized immediately that this story had layers beyond the surface drama. Her first call was to Sheriff Ivana Sanders, who oversaw all courthouse security operations. Sheriff Sanders, a 15-year veteran of law enforcement, had already reviewed the incident reports and begun internal discussions about policy changes. Ms. Brooks, I can confirm that an incident occurred this morning involving one of our officers and Judge Washington. We're conducting a thorough review of our procedures and implementing immediate training improvements. Brooks made notes rapidly. Sheriff, have there been similar incidents involving assumptions about people's roles or status in the courthouse? Sanders paused, clearly choosing her words carefully. We haven't had any formal complaints, but this incident has prompted us to examine whether our current protocols might inadvertently create barriers for court users. The reporter's next call was to Court Administrator Linda Parker, who managed all non-judicial operations for the Hamilton County court system. Parker had spent the morning in crisis management mode, fielding calls and coordinating responses across multiple departments. Ms. Parker, how common are incidents where court users are challenged or questioned about their presence in courtrooms? Parker's response was diplomatic but revealing. Ms. Brooks, we're committed to ensuring all court users feel welcome and respected. This morning's incident has highlighted the need for clearer protocols and enhanced training. What Brooks found most interesting wasn't what officials were saying, but what they weren't saying. The careful language suggested this wasn't an isolated incident, but rather the first time such an incident had been live-streamed and gone viral. Meanwhile, at the Ohio Civil Rights Commission, Director Marcus Johnson had already assigned investigator Patricia Reed to examine the housing court discrimination case involving Damon Clark. Reed's preliminary research had uncovered a pattern of selective lease enforcement by Riverside Property Group. The property management company owned 247 rental units across Hamilton County. Reed's analysis of eviction filings over the past 2 years showed a disturbing trend. Black tenants were evicted for lease violations at a rate 340% higher than white tenants, even when the alleged violations were identical. Reed pulled the lease file for Jeffrey Adams, the white tenant Judge Washington had mentioned during the hearing. Adams operated a computer consulting business from his apartment, maintained business licenses, advertised online, and conducted client meetings in his residence. No eviction proceedings had ever been initiated against him. In contrast, Damon Clark had faced eviction for helping neighbors with minor repairs, generating minimal income, and conducting no formal business activities from his residence. Reed's investigation expanded to examine other Riverside Property Group cases. She discovered that white tenants were typically warned about lease violations before facing eviction proceedings, while black tenants were served immediate eviction notices for first-time violations. The data painted a clear picture of discriminatory enforcement that extended far beyond Damon Clark's individual case. Back at Channel 7 News, Jasmine Brooks was building a comprehensive story that went beyond the morning's dramatic incident. Her research had uncovered Officer Kevin Miller's personnel file, which contained no previous complaints or disciplinary actions, but also showed minimal diversity training beyond basic annual requirements. Brooks interviewed Dr. Rebecca Martinez, a professor of criminal justice at the University of Cincinnati, who specialized in bias in law enforcement. What we saw this morning represents a common phenomenon in institutional settings, Dr. Martinez explained. When authority figures make rapid assessments about who belongs in certain spaces, they often rely on unconscious biases about race, class, and appearance. Professor Martinez's research had documented similar incidents across various institutional settings. Her 2024 study found that black professionals were questioned about their presence in courthouses, law offices, and government buildings at rates significantly higher than their white counterparts. The interesting aspect of Judge Washington's response is that he immediately recognized this as a systemic issue rather than an individual problem. His focus on training and policy changes demonstrates an understanding of how institutional bias operates. Brooks was particularly interested in the broader implications of the incident. Her investigation had revealed that Hamilton County Housing Court processed over 12,000 eviction cases annually, affecting approximately 30,000 residents. If bias was affecting how people were treated in this system, the impact extended far beyond individual cases. Her interview with former housing court clerk Janet Thompson provided additional context. Thompson had worked in the courthouse for 8 years before retiring in 2024, and she was willing to speak candidly about patterns she'd observed. "I saw it happen regularly," Thompson told Brooks during their phone interview. "People would come in for hearings dressed in work clothes or casual attire, and security would automatically assume they were tenants rather than property owners or business representatives. It happened to black folks more than white folks, that's for sure." Thompson recalled specific incidents where black attorneys had been questioned about their presence in restricted areas, while white attorneys moved freely through the same spaces without challenge. Judge Washington always treated everyone fairly once the court was in session, Thompson continued. But what happened before people got to his courtroom was a different story. Security, clerks, and other court personnel sometimes made assumptions that affected how people were treated. Brooks reached out to the National Association for the Advancement of Colored People local chapter, where President Lawrence Davis had been monitoring the housing court situation closely. This incident represents a microcosm of systemic bias that affects African Americans in institutional settings daily, Davis explained. The difference is that Judge Washington had the authority and platform to address it immediately and publicly. Davis's organization had received complaints about courthouse treatment over the years, but most people who experienced bias were focused on their legal problems and didn't file separate complaints about discriminatory treatment by court personnel. What Judge Washington did this morning was use his position to shine a light on problems that have existed for years but were rarely addressed directly, Davis continued. At Hamilton County Community College, sociology professor Dr. Angela Fraser was already incorporating the morning's incident into her afternoon class on institutional racism. Dr. Fraser, who held a PhD from Howard University, had been studying bias in local government institutions for over a decade. What makes this case particularly significant is the intersection of multiple forms of bias, she explained to her students. We see assumptions based on race, class, age, and professional status all converging in a single incident. One student raised her hand. "Professor Fraser, why didn't Judge Washington get angry or try to punish the officer more severely?" Dr. Fraser smiled at the insightful question. Judge Washington understood that individual punishment doesn't change systems. His focus on training, policy changes, and documentation shows a sophisticated understanding of how to create lasting institutional change rather than just addressing one person's behavior. The class discussion that followed explored how the incident demonstrated both the persistence of bias and the potential for systematic solutions when people in authority positions chose to address problems constructively. Meanwhile, social media analysis was revealing fascinating patterns in public response to the incident. The hashtag Housing Court Justice had been used over 15,000 times, with responses varying significantly across demographic lines. Twitter user at Legal Reform shared the live stream with commentary. "This is how you handle discrimination. Document everything. Stay calm. Focus on systematic change, not individual revenge. Instagram user at Tenant writes, posted screenshots from the hearing with the caption, "Judge Washington just showed masterclass in using authority for justice instead of retaliation. More officials should take notes." But not all responses were positive. Some social media users criticized Judge Washington's handling of the situation, suggesting he should have pursued more severe disciplinary action against Officer Miller. As Courtroom Watch tweeted, "Nice that he stayed calm, but that officer should face serious consequences. Being polite about discrimination doesn't stop discrimination." The debate reflected broader disagreements about how to address systemic bias, through individual punishment, systematic change, or combinations of both approaches. Local attorney Michael Stevens, who represented tenants in housing court, had watched the live stream with professional interest. Stevens had practiced housing law for 12 years and had observed the courthouse dynamics Judge Washington addressed. "I've seen my clients questioned and treated with suspicion based on their appearance," Stevens told reporter Jasmine Brooks. "What Judge Washington did was make visible the bias that affects people every day, but usually goes unaddressed." Stevens recalled representing a black businessman who owned several rental properties, but was repeatedly assumed to be a tenant rather than a landlord when he appeared in housing court. The man had eventually stopped appearing personally and sent a white property manager to represent his interests, purely to avoid the constant microaggressions. "The psychological toll of constantly having your credibility questioned based on appearance is exhausting," Stevens explained. Judge Washington's response this morning addressed not just the immediate incident, but the broader pattern that affects so many people. Stevens planned to reference the incident in future training sessions for new attorneys, using it as an example of how bias could affect client treatment even before cases reached the courtroom. At Riverside Property Group's corporate office, emergency meetings were underway to address the discrimination allegations raised during Damon Clark's hearing. Property manager Jennifer Walsh had spent the morning reviewing tenant files and eviction procedures, trying to understand how their enforcement patterns had become so obviously discriminatory. The company managed 247 rental units and had processed 89 eviction cases in the past 18 months. Walsh's analysis revealed that black tenants represented 31% of their rental population, but 67% of their eviction cases, even when controlling for income levels and the lease terms. More troubling was the discovery that white tenants typically received warnings for lease violations, while black tenants received immediate eviction notices. The pattern was so consistent it suggested either explicit policy or systematic bias in enforcement decisions. Walsh's legal review of Jeffrey Adams' situation confirmed Judge Washington's observations. Adams operated a clear commercial business from his residential apartment, maintained business licenses, advertised online, and conducted regular client meetings in his unit. No eviction proceedings had ever been considered, despite obvious lease violations. The company's attorney, Robert Martinez, was already drafting new enforcement protocols designed to ensure consistent treatment regardless of tenant demographics. Martinez understood that the Ohio Civil Rights Commission investigation could result in significant penalties if discriminatory patterns were confirmed. "We need to implement blind review processes for lease violations," Martinez recommended. "Initial violation assessments should be made without reference to tenant names or photographs to eliminate unconscious bias in enforcement decisions." Meanwhile, Officer Kevin Miller was experiencing his own process of reflection and learning. The morning's incident had forced him to confront assumptions he hadn't previously recognized in his own thinking and behavior. Miller contacted the Hamilton County Community Relations Office to inquire about additional bias training beyond what Judge Washington had mandated. He wanted to understand not just what he'd done wrong, but how to recognize and address similar biases in his future interactions. Community Relations Director Lisa Johnson connected Miller with Dr. Patricia Davis, a psychologist who specialized in unconscious bias training for law enforcement personnel. Officer Miller, Dr. Davis explained during their initial consultation, "What you experienced this morning is actually quite common. Most people harbor unconscious biases that affect their judgments about others. The key is developing awareness and strategies for making more objective assessments." Dr. Davis's training program focused on practical techniques for law enforcement officers to pause and verify assumptions before taking action. The program included scenarios, role-playing exercises, and real-world applications designed to reduce bias-driven mistakes. Miller found the training revelatory. He began to recognize how many times he'd made rapid judgments about people's roles or intentions based on limited visual information. The housing court incident wasn't an aberration. It was an example of thinking patterns that had affected his interactions for years without his conscious awareness. Back at Channel 7 News, Jasmine Brooks was preparing her evening broadcast package about the housing court incident. Her investigation had uncovered layers of systemic issues that extended far beyond the morning's dramatic confrontation. Brooks had documented discriminatory enforcement patterns in rental housing, bias in courthouse security procedures, and inadequate training protocols for court personnel. But she'd also found examples of positive change already beginning to emerge from Judge Washington's response. The Hamilton County Bar Association had announced plans for enhanced bias training for all member attorneys. The Ohio State court system was considering new guidelines for courthouse security protocols. Local law schools were incorporating the incident into their professional responsibility curricula. Brooks's story would air during the 6 p.m. newscast, reaching approximately 200,000 viewers across the metropolitan area. But she knew the real impact would come from the systematic changes the incident had catalyzed rather than just the media coverage. Her final interview was with Judge Washington himself, conducted in his chambers after the afternoon court session had concluded. "Your Honor, how do you hope this incident will affect the broader justice system?" Judge Washington considered the question carefully before responding. "Ms. Brooks, individual incidents of bias happen constantly throughout our justice system. They're usually invisible, unrecorded, and unaddressed. This morning's incident was different only because it was live-streamed and involved someone with the authority to respond immediately." The judge continued, "My hope is that other institutions will examine their own procedures and training to identify where bias might be affecting access to justice. Real change happens when we address systems, not just individual incidents." Brooks asked about the personal impact of being subjected to discriminatory treatment despite his position and authority. "It was frustrating," Judge Washington admitted, "but not surprising. Bias affects everyone, regardless of their professional status or achievements. The difference is that I had the platform and authority to address it immediately. Most people who experience similar treatment don't have those advantages." The interview concluded with Judge Washington's broader perspective on institutional change and the role of leadership in addressing systemic problems. People in authority positions have a responsibility to use their platforms for positive change when they encounter bias or discrimination. This morning provided an opportunity to demonstrate how that responsibility can be fulfilled constructively. As Brooks finished editing her story that evening, she reflected on how a single incident had revealed so many layers of systemic issues, while also demonstrating the potential for rapid positive change when leadership chose to address problems directly rather than defensively. The evening newscast would inform thousands of viewers about the incident, But the real story was the institutional changes already beginning to emerge from Judge Washington's measured but decisive response to discrimination in his own courtroom. 3 weeks after the housing court incident, transformation was already visible throughout the Hamilton County Courthouse system. The Conference Room A at the County Administration Building had been converted into a training facility, where Court Administrator Linda Parker was conducting the first session of mandatory bias recognition training for all courthouse personnel. Officer Kevin Miller sat in the front row, taking careful notes as Dr. Patricia Davis presented scenarios designed to help participants recognize their own unconscious biases. The irony wasn't lost on anyone that Miller had become the case study for exactly the type of thinking the training was designed to address. "Let's examine a common scenario," Dr. Davis said, displaying a photograph on the projection screen. "You see someone in casual clothing sitting in a restricted area of the courthouse. What assumptions might you make about their purpose or authority?" The photograph showed a professionally dressed black woman in business attire, but Dr. Davis had described her as wearing casual clothing to test whether participants would rely on the visual evidence or the verbal description informing their judgments. Miller raised his hand. "Dr. Davis, 3 weeks ago, I would have made assumptions based on appearance without gathering additional information. Now I understand the importance of verification before taking any action." The training sessions had been designed based on Judge Washington's recommendations, incorporating real-world scenarios from courthouse operations. Each session included role-playing exercises where participants practiced verification techniques and respectful interaction protocols. Sheriff Ivana Sanders attended every training session, demonstrating leadership commitment to institutional change. Her presence sent a clear message that bias recognition wasn't just another bureaucratic requirement, but a genuine priority for courthouse operations. Sheriff Sanders addressed each group personally. "3 weeks ago, we had an incident that revealed gaps in our training and procedures. Rather than viewing this as a failure, we're using it as an opportunity to become a model courthouse system for other counties to emulate." The training curriculum included modules on unconscious bias, cultural competency, de-escalation techniques, and professional communication standards. Participants learned to recognize when they were making assumptions and practiced verification techniques that maintained security while respecting all courthouse users. Dr. Davis had developed the program specifically for courthouse environments, understanding that security personnel needed practical tools for distinguishing between legitimate security concerns and bias-driven assumptions. "Your job is to maintain safety and order," Dr. Davis explained to the security officers. "These skills help you do that job more effectively by reducing conflicts caused by misunderstandings and ensuring you're responding to actual situations rather than assumptions." Meanwhile, at the Ohio Civil Rights Commission, investigator Patricia Reed had completed her examination of discriminatory enforcement patterns in housing court cases. Her findings were more extensive than anyone had initially suspected. Reed's analysis of 2,847 housing court cases over the past 3 years revealed systematic disparities in how tenants were treated based on race, economic status, and legal representation. Black tenants were 280% more likely to face immediate eviction proceedings for first-time lease violations, while white tenants typically received warnings and opportunities to correct problems. The investigation had expanded beyond Riverside Property Group to examine enforcement patterns across all major property management companies in Hamilton County. Reed discovered that discriminatory enforcement was industry-wide, not limited to individual companies or properties. Her report documented specific examples of selective enforcement: white tenants operating businesses from residential units without consequences, while black tenants faced eviction for minimal commercial activities, white tenants receiving multiple warnings for lease violations, while black tenants were served immediate eviction notices for identical infractions. Commissioner Marcus Johnson planned to use Reed's findings to establish new oversight protocols for housing court proceedings, ensuring that discriminatory enforcement patterns would be identified and addressed before they affected hundreds of families. The Commission's recommendations would require property management companies to document their enforcement decisions and demonstrate consistent application of lease terms, regardless of tenant demographics. At Hamilton County Community College, Dr. Angela Fraser was documenting the incident's impact on her students and incorporating it into a research project about institutional bias recognition and response. Her students had been following the courthouse training implementation and analyzing social media responses to Judge Washington's handling of the incident. The project examined how different communities perceived and responded to institutional bias when it was addressed constructively rather than defensively. Student research revealed fascinating patterns in public reaction. Communities that had experienced similar discrimination generally praised Judge Washington's systematic approach, while communities with less direct experience sometimes preferred more punitive responses to individual bias incidents. One student, Jennifer Adams, a criminal justice major, chose to focus her senior thesis on the incident's demonstration of leadership approaches to institutional change. Judge Washington showed that people in authority positions can use their power to create systematic improvements rather than just addressing individual problems, Adams wrote. His response demonstrated how to transform conflict into an opportunity for positive change. Adams interviewed courthouse personnel, community leaders, and legal professionals to understand how the incident had affected institutional culture beyond just policy changes. Her research found that the incident had created what sociologists called a teachable moment that allowed people to discuss bias and discrimination more openly than typically occurred in professional settings. At the National Association for the Advancement of Colored People local chapter, President Lawrence Davis was using the housing court incident as a model for addressing institutional bias in other local government agencies. Davis had initiated discussions with the city police department, school district, and social services agencies about implementing similar bias recognition training and accountability measures. What Judge Washington demonstrated is that institutional bias can be addressed proactively rather than just reactively, Davis explained during a community meeting. Instead of waiting for discrimination complaints, institutions can examine their own procedures and make improvements before problems affect more people. The NAACP was documenting the courthouse changes as a case study for other communities facing similar institutional bias issues. Davis planned to present the Hamilton County model at the organization's state conference as an example of effective institutional reform. Meanwhile, Riverside Property Group had implemented comprehensive changes to their tenant relations and enforcement procedures. Property manager Jennifer Walsh had developed new protocols requiring documentation and justification for all enforcement decisions. The company's new procedures included blind review processes, where initial enforcement recommendations were made without reference to tenant names, photographs, or demographic information. All enforcement decisions required approval from 2 separate managers, and patterns were reviewed monthly to identify potential bias. Walsh had also implemented tenant communication improvements, ensuring that all residents received clear explanations of lease terms and violation correction procedures before facing eviction proceedings. The changes weren't just defensive responses to the discrimination investigation. Walsh recognized that fair and consistent enforcement actually reduced turnover costs and improved tenant relations, benefiting the company's long-term financial interests. Our previous enforcement patterns were not only discriminatory, they were bad business, Walsh explained to her management team. Consistent, fair treatment creates better tenant relationships and reduces costly eviction proceedings. At Channel 7 News, reporter Jasmine Brooks continued following the story's development, documenting how the incident had catalyzed changes extending far beyond the original courthouse setting. Brooks discovered that the housing court training model was being adopted by courthouses in 6 other Ohio counties, with inquiries from court systems across the Midwest about implementing similar programs. The Ohio State Court System had announced plans to develop standardized bias recognition training for all court personnel statewide, using the Hamilton County model as the foundation curriculum. Brooks interviewed Chief Justice Maria Rodriguez of the Ohio Supreme Court, who praised Judge Washington's approach to institutional reform. Judge Washington demonstrated exceptional leadership by transforming a potentially divisive incident into an opportunity for positive systematic change, Chief Justice Rodriguez stated. His response provides a model for how judicial leadership can address bias constructively while maintaining public trust in court systems. The interview revealed that the Ohio Supreme Court was considering new rules requiring all court systems to implement bias recognition training and establish protocols for addressing discrimination incidents. Back in his chambers, Judge Washington was reviewing implementation reports from the various training and policy initiatives that had emerged from the original incident. The courthouse security training had achieved 100% completion rates, with follow-up assessments showing measurable improvements in personnel's ability to recognize and address their own biases. The Ohio Civil Rights Commission investigation had resulted in industry-wide changes to housing enforcement practices, affecting thousands of tenants across Hamilton County. Local law schools had incorporated the incident into their professional responsibility curricula, ensuring that future attorneys understood their role in addressing institutional bias. Most importantly, courthouse climate surveys showed that court users reported feeling more respected and fairly treated since the training implementation. Judge Washington's assistant, Maria Santos, brought him a folder containing letters from people who had been affected by the changes. One letter was from Mrs. Betty Foster, the elderly woman whose eviction case had been resolved fairly during the morning session 3 weeks earlier. Judge Washington, Mrs. Foster wrote, "I wanted you to know that my landlord accepted the payment plan you suggested. I'm still in my apartment and I'm caught up on my rent. But more than that, when I went to court that day, I saw how you treated everyone with respect and dignity. It gave me hope that the system can work fairly for people like me." Another letter came from David Kent, the college student who had successfully defended against fraudulent damage charges. "Your Honor," Kent wrote, "watching how you handled discrimination in your own courtroom inspired me to change my major to pre-law. I want to work for justice like you demonstrated that morning. Thank you for showing that one person can make a difference in how institutions treat people." Perhaps the most significant letter came from Damon Clark, whose discrimination case had been dismissed and referred for civil rights investigation. "Judge Washington," Clark wrote, "I never expected justice when I walked into that courtroom facing eviction for helping my neighbors with repairs. But you didn't just save my apartment, you changed how the whole system works." The property management company called to apologize and explain their new, fair enforcement policies. "Other tenants in my building are being treated better, too." Judge Washington reviewed the quarterly reports from all the initiatives that had emerged from the original incident. The data showed measurable improvements in courthouse climate, reduction in bias-related complaints, and increased public confidence in court system fairness. But the most gratifying outcome was personal. The incident had demonstrated that individual leadership could catalyze systematic change when approached with the right combination of documentation, leverage, and commitment to institutional improvement rather than personal retaliation. Judge Washington's phone rang with a call from Judge Patricia Martinez of the Lucas County Housing Court in Toledo. Judge Washington, I've been following the changes you've implemented since your courthouse incident. We're dealing with similar bias issues in our system. Could you share your training protocols and policy recommendations? The conversation lasted 45 minutes with Judge Washington providing detailed guidance about implementing bias recognition training, establishing accountability measures, and creating systematic change rather than just addressing individual incidents. Judge Martinez, the key is understanding that individual bias incidents usually reflect systematic problems that require institutional solutions, Judge Washington explained. Punishing individuals without changing systems just drives bias underground instead of eliminating it. After ending the call, Judge Washington reflected on how a single morning's discriminatory treatment had become a catalyst for changes affecting thousands of people across multiple states. The transformation had been possible because he'd chosen to view the incident as an opportunity for education and improvement rather than just a personal offense requiring individual punishment. As he prepared for the afternoon court session, Judge Washington considered the broader implications of institutional leadership and the responsibility that came with authority to create positive change when bias and discrimination were encountered. The housing court incident had become a case study in leadership, but more importantly, it had become a model for how institutions could address bias proactively and systematically rather than just reactively and individually. The court would resume in 15 minutes, but the lessons from that morning 3 weeks ago would continue influencing how justice was administered long after the final gavel fell. 6 months after the housing court incident, Judge Terrence Washington stood before the National Conference of Housing Court Judges in Chicago, delivering the keynote address about institutional bias recognition and systematic reform. The auditorium contained 300 judges from across the United States, each representing court systems that processed thousands of housing cases annually. Transformation doesn't require dramatic confrontation, Judge Washington told the assembled judges. It requires recognition of opportunity, documentation of problems, and systematic implementation of solutions. What happened in Hamilton County demonstrates how individual incidents can become catalysts for institutional change when leadership chooses education over retaliation. He clicked to his first slide, showing statistics from the 6 months since the training implementation. Housing court discrimination complaints had decreased by 89% countywide. Tenant satisfaction surveys showed measurable improvements in perceptions of fair treatment. Most significantly, eviction rates had stabilized as property management companies implemented consistent enforcement practices. The data proves that addressing bias doesn't just improve justice outcomes, it improves institutional efficiency and public trust, Judge Washington continued. In the audience, Judge Patricia Martinez of Lucas County nodded approvingly. She had implemented similar training in her courthouse after consulting with Judge Washington, achieving comparable results in reducing bias incidents and improving court user satisfaction. Judge Martinez raised her hand during the question and answer session. Judge Washington, how do you maintain momentum for institutional change after the initial incident publicity fades? Judge Washington had anticipated this question. Systematic change requires ongoing measurement and accountability, not just one-time training events. We conduct quarterly bias assessment surveys maintain anonymous reporting systems, and require regular refresher training for all personnel. Change must be sustained through continuous attention, not just initial enthusiasm. The conference attendees were taking detailed notes, recognizing that Judge Washington had developed a replicable model for addressing institutional bias in court systems nationwide. After his presentation, Judge Washington was approached by representatives from the American Bar Association, the National Center for State Courts, and several judicial education organizations interested in incorporating his approach into their training curricula. Back in Hamilton County, the changes had become embedded in routine courthouse operations rather than special initiatives. Officer Kevin Miller had completed advanced bias recognition training and was now helping to train new security personnel in verification techniques and respectful interaction protocols. Miller's transformation had been remarkable. The morning's incident that initially seemed like career-ending embarrassment had become the foundation for his professional development and institutional contribution. I learned more about effective law enforcement in the 3 weeks after that incident than I had in my previous 6 years of service, Miller reflected during an interview with researchers from the University of Cincinnati who were documenting the courthouse changes. Miller had volunteered to share his experience at training sessions for other law enforcement agencies, helping officers understand how unconscious bias could affect their professional effectiveness and community relationships. The incident taught me that assumptions based on appearance don't just hurt other people, they make me less effective at my job, Miller explained. When I rely on evidence and verification instead of assumptions, I make better decisions and build better relationships with the people I'm supposed to serve. At the Ohio Civil Rights Commission, Director Marcus Johnson was preparing the final report on discriminatory enforcement patterns in housing court cases. The investigation had expanded to include 47 property management companies and had documented systematic bias affecting over 12,000 tenants annually. The Commission's findings had prompted new state legislation requiring consistent enforcement documentation and regular bias audits for all property management companies receiving government subsidies or tax incentives. Representative Angela Thompson, who sponsored the legislation, credited Judge Washington's handling of the original incident with providing the political momentum necessary for systematic reform. Judge Washington's response demonstrated that individual bias incidents reflect institutional problems requiring legislative solutions, Representative Thompson explained during the bill's passage. His systematic approach provided a model for how we should address discrimination in all institutional settings. The legislation, known as the Fair Housing Enforcement Act, required property management companies to document enforcement decisions, maintain demographic data on tenant treatment, and submit to annual bias audits conducted by independent organizations. Non-compliant companies would lose access to government contracts and tax incentives, creating financial incentives for consistent fair treatment regardless of tenant demographics. At Riverside Property Group, property manager Jennifer Walsh was documenting the business benefits of fair and consistent enforcement practices. The company's new protocols had reduced tenant turnover by 34%, decreased eviction costs by 52%, and improved online reviews significantly. Walsh presented her findings at the National Property Management Association conference, demonstrating that eliminating discriminatory practices benefited companies financially while improving tenant relations. Our previous enforcement patterns weren't just morally wrong, they were economically inefficient, Walsh explained to conference attendees. Fair treatment creates better tenant relationships, reduces turnover costs, and minimizes legal liability. The presentation sparked industry-wide discussions about the business case for eliminating bias in property management, leading to voluntary adoption of fair enforcement protocols by companies across multiple states. At Hamilton County Community College, Dr. Angela Fraser had completed her research project analyzing community responses to Judge Washington's handling of institutional bias. Her findings had been published in the Journal of Applied Social Psychology and were being cited by researchers nationwide. Dr. Fraser's research revealed that communities responded more positively to systematic approaches to bias than to individual punishment approaches. Judge Washington's focus on institutional change rather than personal retaliation had generated broader support for anti-discrimination efforts. The study showed that transformative leadership approaches to bias incidents created sustainable change, while punitive approaches often generated defensive responses that hindered long-term progress. Her research had been incorporated into leadership training programs for judges, court administrators, and other institutional leaders facing discrimination issues. Media coverage of the incident and its aftermath had continued for months, but with focus shifting from the dramatic confrontation to the systematic changes it had generated. Jasmine Brooks had won a regional journalism award for her comprehensive coverage of institutional bias and reform in the courthouse system. Her follow-up stories had documented implementation progress, measured outcomes, and analyzed the replication of similar programs in other jurisdictions. Brooks's final article in the series examined the national impact of Judge Washington's approach, documenting similar training implementations in 23 states and federal court system policy changes influenced by the Hamilton County model. The incident had become more than local news. It had become a national case study in institutional leadership and systematic bias elimination. At the Transportation Equality Foundation, which had been established after Marcus Chen's airline incident, 2 years earlier, Executive Director Patricia Voss was collaborating with Judge Washington's team to develop bias recognition training for all transportation and institutional settings. The foundation had documented that the principles demonstrated in the courthouse incident applied broadly to airports, train stations, government buildings, and other institutional environments where assumptions about people's roles and status could affect their treatment. Judge Washington's approach perfectly complements our systematic methodology, Dr. Voss explained during a joint training session. Whether the setting is an airplane, a courthouse, or any other institutional environment, the principles remain the same. Document problems, address systems rather than just individuals, and create sustainable change through policy and training improvements. The collaboration had resulted in comprehensive training curricula being adopted by federal agencies, state court systems, and private companies seeking to address institutional bias proactively. 1 year after the housing court incident, Hamilton County had become a destination for delegations from other jurisdictions seeking to understand and replicate the systematic changes that had emerged from Judge Washington's response to discrimination. Judge Washington regularly hosted visiting groups, sharing implementation strategies, training materials, and assessment tools with representatives from court systems across the country. The key insight is that individual incidents of bias usually reflect systematic institutional problems, Judge Washington explained to a delegation from California's court system. Addressing the system creates sustainable change that prevents future incidents rather than just responding to them after they occur. The visitors toured the courthouse, observed training sessions, and interviewed court users about their experiences since the bias recognition initiatives had been implemented. Their feedback consistently praised the comprehensive approach and the measurable improvements in courthouse climate and user satisfaction. Judge Washington had also been invited to speak at Harvard Law School, Yale Law School, and other prestigious institutions about institutional leadership and systematic bias elimination. His presentations always emphasized practical implementation rather than theoretical concepts, providing specific tools and strategies that could be adapted to various institutional settings. Legal education had been transformed by incorporation of his case study into curricula nationwide. Future lawyers were learning about their responsibility to address institutional bias and their role in creating systematic change rather than just individual representation. The American Bar Association had established the Washington Award for Institutional Leadership, recognizing individuals who used their authority to address discrimination through systematic rather than punitive approaches. Judge Washington was the inaugural recipient, but he used his acceptance speech to emphasize that institutional change required collective commitment rather than individual heroism. Real transformation happens when institutions commit to continuous improvement, rather than relying on dramatic individual responses to bias incidents. He told the assembled legal professionals, "My experience in housing court was significant only because it demonstrated systematic approaches that any institution can implement." 2 years after the incident, the Hamilton County Housing Court had become a model for fair and effective judicial administration. Discrimination complaints had virtually disappeared. Tenant satisfaction ratings exceeded national averages, and the court system was processing cases more efficiently than ever before. Judge Washington's caseload had remained the same, but the institutional culture had been transformed. Court users reported feeling respected and fairly treated, regardless of their appearance, economic status, or legal representation. The systematic changes had created a courthouse environment where bias incidents were unlikely to occur and would be addressed immediately if they did emerge. Officer Kevin Miller had been promoted to training coordinator for courthouse security, using his experience and transformation to help other officers develop effective bias recognition skills. Miller's story had become part of the standard training curriculum, demonstrating that acknowledging and learning from mistakes could lead to professional growth and improved community service. Mrs. Betty Foster still lived in her apartment, having successfully maintained the payment plan that Judge Washington had facilitated. She often spoke at community meetings about the importance of fair treatment in institutional settings. David Kent had graduated from college and was attending law school, inspired by Judge Washington's demonstration of how legal professionals could create positive systematic change. Damon Clark continued living in his apartment without harassment, and the property management industry's adoption of fair enforcement practices had improved conditions for thousands of other tenants. The housing court incident had become more than a viral video or a news story. It had become a catalyst for institutional transformation that affected thousands of people's lives and created a replicable model for addressing bias in institutional settings. Judge Washington often reflected on how a single morning's discrimination had generated years of positive change, affecting multiple institutions and thousands of individuals. The incident had demonstrated that individual leadership could create systematic transformation when approached with the right combination of documentation, strategic thinking, and commitment to institutional improvement rather than personal retaliation. As he prepared for another day of housing court proceedings, Judge Washington considered the continuing responsibility that came with institutional authority and the ongoing opportunity to ensure that justice was administered fairly and respectfully for all court users. The morning that had begun with assumptions and bias had generated a legacy of systematic change that would continue affecting how institutions address discrimination long after Judge Washington's own service concluded. The transformation was complete, but the commitment to continuous improvement remained ongoing, ensuring that the lessons learned from one incident of bias would prevent countless future incidents through systematic institutional change. The court would begin in 15 minutes, but the principles established through that morning's events would continue guiding how justice was administered for generations of court users to come.